I think instinctively, I always think if you have a right, you should assert it. And if there is a request for privileged documents, the first answer that comes out is it's privileged. I'm not going to show it to you. But when it comes to investigations, sometimes it depends on what you are trying to achieve, right? It's really case by case. If you were negotiating a deferred prosecution agreement with the enforcement authority, for example, then if it would be the interest to further those discussions by disclosing some of the privileged information, then that goes into the balance of the factors that you would consider in coming to that decision. If you disclose, like what Colin said, you would be risking a waiver of privilege, and it may also take you down an inquiry into other documents that they realize are in existence because they see these initial documents. But if you don't disclose, it may be a sign of the company trying to be not cooperative with the regulator. And if you were trying to get some kind of non-prosecution or deferred prosecution agreement, it may be harder for you to do so. So I think it's down to the facts and it's down to the issues. If they are after some information that they claim is contained in those privileged documents, then consider if there are other documents or other forms of clarification you could provide to them to address those questions they have, rather than disclose the privileged documents. And then that may address their concerns and let them not be after you so much for those particular documents. So it really depends on the facts and the issues and what they are after, which is why I think as part of our practice, we always consider the substance of the underlying investigation, and we always try and, I think using the word second guess is probably not quite right, but you always try and see what the authorities are after, and make a judgment call on what you should produce and what you shouldn't.